So welcome to the death class. I didn't name it that. Kathy didn't name it that.
No.
But they've already got Dr. Frame's video up on YouTube. So I watched it last night, and I see that somebody or some ones at the church have called it the death class. Well, it's not all about death, is it? No, a lot of we're talking about planning in the event that you become incapacitated during your lifetime and how you manage things during that. But death isn't such a daunting subject for us, is it? Right? As Christians, we are all believers and followers of Christ, and we live in a hope that we will be with our Lord and Savior when we pass over. So really what we're doing is trying to arrange things for the people that are left behind. One phrase. I'm not going to steal that phrase, but the people that are left behind need help. And to let you know how I even know what I'm talking about, I'll tell you a little bit about me. My name's Bob Ferris. I'm an attorney, but I'm retired now. But I became a judge here in Tulsa County early in my life. Are we good? For almost a decade. And in that 10-year period, they assigned you to different courts. In the last 5 years, I was assigned to what's called the probate court. The probate court is the court that deals with the estates of people who have died. And I didn't know much about it when I first got assigned there, but let me tell you, after 5 years and hearing those cases every day, I learned a lot about estate planning, wills, trust, powers of attorney. In probate court, there are no juries. So every time there was a trial, it was just me. I had to listen to the evidence and make a decision and read the attorney's briefs. And so I really did learn a lot about it, and I found that I was really interested. I really enjoyed it. When I left the courthouse, I went back into private practice, but I joined a little law firm. That's all they did was estate planning. So I specialized in that. And what I didn't realize was that a year later at the University of Tulsa Law School, they called me and said, well, you just got off the bench as a probate judge. We need somebody to teach a class on wills and trusts. Can you do that? And they said, just for a year. Well, somebody says just. That's always a red flag. But I said, okay, I thought that'd be interesting. And it was. I taught it for a year, and then they said, can you do one more year? I can do that. 28 years later, I think you're through. No, I retired. So I've been teaching wills and trusts for a long time. And that's a 4-hour class that goes for a full semester. And I have an hour tonight to tell you everything I know. It took me 4 hours in each class session or each week for a semester, which means obviously we're just going to kind of barely get the tip of the iceberg here. But we're going to talk about estate planning tonight. I saw that Dr. Frame did the medical part last Wednesday. He did a great job. He's a great doctor. And we talk about will. Let's just start somewhere. No, let's start this. You all have this little handout. When we talk about estate planning, it's all about figuring out what assets you own and how you're going to do it. So let me tell you, when I was in practice, and somebody would come to me and say, my spouse just died, and I have named the executor in his or her will, and I need to know what I need to do. My question was, well, what did your spouse own? And invariably the answer was, I don't know. I don't know. And we're going to probate his or her estate? Yikes. So then becomes a wild goose chase at the treasure hunt, trying to figure out what the deceased person owns. That's what this is about. Our church has provided this booklet for you to fill out to list all your assets. So if you look at the very first page, or look at the number 1, 2/3 of the way down, make a list of all your assets. You make the list in here so that in the event you become incapacitated or certainly at your death, someone's going to step in and try and take over and manage your property. But they don't know what your property is unless you have a list somewhere. You are the only one that knows what property you own and where it is located and what the account numbers are. A lot of times when I had that situation, my clients didn't know what assets their spouse owned. I said, well, we can wait until February of next year. Why would I wait until February of next year to figure it out? Anybody got a guess? What happens in February?
Tax forms.
Tax forms. Your 1099s get mailed to the deceased, showing what they're at, what that account was, and how for tax purposes. So we had to wait. Let's say they died, and so we had to wait till February of next year to get the 1099s to figure out how many accounts they owned, where they were. Oftentimes the spouse had no clue. And so it really was just a wild goose chase. But if you would take the time to sit down and fill this out, it would be extremely helpful. not only at your death, but again, if you become incapacitated. We're going to talk about the financial power of attorney. Dr. Frame talked about a healthcare power of attorney, extremely important, but there's a second kind of power of attorney, which is called the financial power of attorney, and I attached one that I handed out tonight. And just like in a healthcare power of attorney, you're going to appoint an agent who will handle your financial affairs if you become incapacitated. And you may be thinking, oh, that's not going to happen to me. I'll never become incapacitated. Well, thanks to all the people in Dr. Frame's profession, medical technology it's making all of us live longer and longer. But the longer that you live, the more likely it is that you're going to have some type of illness or incapacity where you won't be able to make decisions anymore, not only about your health, but also about your financial affairs, whether it's a stroke, a car wreck, dementia, you name it. And when I was a judge, another thing the probate court judge does is deal with guardianship. And if you don't have a durable power of attorney and you become incapacitated, that's the next step. The family has to go to court, hire a lawyer, and prove to the judge that you are incapacitated and that I need to appoint a guardian to take care of your mom or your dad or your grandparent, whoever it is. Those are stressful, they're expensive to hire a lawyer to do that. That's the point of having a durable power of attorney, so that somebody can step in, make healthcare decisions for you, make financial decisions for you, so your family isn't forced to hire a lawyer to go to court and file a guardianship. And even if you go to court and do that, that guardianship is going to last until the incapacitated person dies. So every year the guardian has to file an accounting with the court showing exactly what they've done. There's a good side of that because the judge is going to look it over and make sure they're doing what they're supposed to do. But it's just a lot of work. So I urge you to fill this out, list your assets, list your real estate. You need the legal description of your home. That's going to be on the deed that you got when you bought your home. If you don't have your deed, you can get access to it at the Salisbury County Clerk's office. But that would be extremely helpful because people hardly ever know the legal description of their real estate. One thing I noticed that is not in here, we live in the computer age now, don't we? The digital age. Don't we all have all kinds of digital accounts and assets? Your Facebook account has all kinds of personal stuff about you, your X account, all these different accounts. It's an oversight. I didn't see this until just a few days ago, and so it needs to be updated because there needs to be a page on there where you can put those type of online accounts, because otherwise your family member who's, let's say, your personal representative for your state or your trustee in your trust, they're going to need access to those accounts. A lot of you want shut down, right? If you have a Facebook account and you have all kinds of photos on it, I would suspect that you probably wish that account would just be deleted when you die. Well, it's difficult if they don't have access to your accounts and they won't know how to get in. They won't know your user ID, they won't know your password. And guess what? When they email Facebook and say, my mom died and I need to know her user ID and the password, they're just going to laugh and go, that's what everybody says. This is a scam. No, it's not a scam. How do you convince them? You don't convince them. So, this is interesting. So I was thinking about that today. Just about 4 hours ago, I was eating lunch in our kitchen and the mailman brought this. And I think most of the people who look like you're of the age that you probably get the AARP bulletin, which I got today. So I'm sitting there eating lunch, and right here on the top, I circled something that says, keep paper safe, how to store documents in a digital vault. Am I the only one here that doesn't know what a digital vault is?
I don't.
Well, if you get this bulletin, or you can have mine because I read it, read about a digital vault. Well, what it is, it's an online service where you can keep copies of your documents. You'll need a way to make a PDF version of your documents. If you have a scanner, that's great. If you don't have a scanner, almost all smartphones have a scanning app, or you can use the camera. You make a PDF, you upload them to these companies, and they keep them, and you have to categorize them, so it's kind of a filing system. They're kept online, and of course, when you hear that, you think, well, that doesn't sound very safe. People like that get hacked. According to this article, there's an extra layer of security on these type companies that you wouldn't even have in Facebook or X, in that the companies that put these out there, they can't even get into your documents. Only you can, and they're going to have some kind of fingerprint ID or face recognition or double authentication so that you can get into it. They cost a little bit of money, and it said they average about $10 a month to get one of these programs. And I told them, that's not that bad. And then they said, but this one company has a bargain for AARP members, and it's $20 a year. And so there was a little QR code at the top of the page, and I looked at my phone and scanned it, and sure enough, for $20 a year, which is a bargain for getting all of your important documents in one place where people can find them, particularly your family is going to need them when you become incapacitated or die. $20 a year, that is a bargain. So take a look at your AARP bulletin that came out today, or you'll get it tomorrow. Okay, enough about that. When people start talking about the fact that we're all going to die, and you need to get your affairs in order, they almost always say, what? You need to get your will. Wills have been around for hundreds of years, and you all know what a will is, right? It's just a document that's prepared either by your lawyer, or you can get a free will form off the internet. There's millions of them. You fill out the form, you have to sign it, of course. It has to have 2 witnesses, and in there you state who's received your property at death. And a will can be as simple as, I, Bob Ferris, being of sound mind, make this last will and testament. I leave all my estate to my wife, Pam, and if she's not living at my death, I leave it to our 2 sons, and so on down the line. And real simple. And I name my wife as the executor of my estate. That's what a will does. But what people don't seem to understand is, use my example I just gave you. So let's say I passed away, and my wife Pam is the executor, and it says she's to get all of my property. How does that happen? How does Pam get my property? Just because she has a will, does she hold it up and the will fairy goes, bing, it's done? It is not done. What she would have to do is hire a lawyer, just like I would have been, and hire them to represent her, to file what's called a probate proceeding in that probate court that I just mentioned I was a probate judge in for 5 years. So you need a lawyer, and I know there's some lawyers here, to take you through probate. And so why would you care about that? There's some downsides of probate that a lot of people are not too big on. Number one is the cost. Attorneys have to make a living. So when I used to do probates, and I did hundreds of them, I didn't do them for free. You know, I charged and at a pretty good hourly rate. So it can be expensive. And to go to any court proceeding, whether it's probate or civil or criminal or anything, it just takes time. You know, if you get a probate done in 6 months, that's a miracle. It's probably going to be 9 months or 12 months or longer. The more complicated your estate is, the longer the probate takes. And the attorney's charging for his or her time for all that. So people aren't real crazy about using wills anymore. In my practice, and I just retired 5 or 6 years ago, almost every client that came into me to do their estate planning kind of knew those downsides of wills. And if they didn't know about revocable trust, I explained it to them. Revocable trusts have become kind of the vehicle of choice for people in estate planning. Like I said, wills have been around for hundreds of years, but revocable trust, or revocable trust, however you want to pronounce it, have really only been popular for the last 50 years. But they're a great vehicle for transferring property at death, and here's how they work. If you were to do a will, you sign the will, and that's it. You don't have to do anything with your property. But if you have a revocable trust, like one that I do for my clients, I had the easy part. I drew the trust up. I asked them a bunch of questions and found out who they wanted to receive their property at death. And then after they signed the trust, just like they did a will, that trust has to be funded. A will does not have to be funded, but a trust has to be funded. By that, I mean you actually have to transfer assets into the trust. I explained it to my clients, just think of it as a basket, and you have to put things in the basket. And if you don't do that, then you die with something that would have to go to probate court. Then you're going to end up in probate court after all. So when I say fund a trust, what do I mean? I mean, it's just paperwork. Like a home. My wife and I own our home. And like most married couples, we own it's what's called joint tenants with right of survivorship. Almost all married couples own a home that way. That simply means when the first of us dies, the title goes to the survivor. But if we set up a trust, the Bob and Pam Ferris Trust, we would have to execute a new deed transferring title, because we're going to be the first trustees. It's going to be the Bob and Pam Ferris trustees of the Bob and Pam Ferris Trust. It's a simple deed form. You fill it out, you take it down and record it at the courthouse, and now that house is now in the trust. That's how you avoid probate with real estate. You transfer title to that real estate into your trust by simply executing it in deed form. There's nothing magic about the deed form. It's the standard deed form you would use for any kind of real estate transaction. But it would no longer be as joint tenants with right of survivorship. It would be as in our name as trustee of our trust. Because, let me back up here. Right now, if a married couple owns their home as joint tenants with right of survivorship, no trust, and one of them dies, if you're not familiar with this term, joint tenancy with right of survivorship, what that means is joint tenants each own the entire asset, 100% each of them, at the same time. So if you own your home with a spouse as joint tenants with right of survivorship, you each own 100%. You don't own 50% and your spouse owns 50%. You each own 100% of it. And then when the first joint tenant dies, because it says with right of survivorship, that means the surviving spouse gets 100% title. It takes the name of the deceased off. And all you have to do to clear the title up is there's a simple affidavit that you fill out and file at the courthouse. And that's done. You don't go through probate. It doesn't need to be in a trust. It's fine. The surviving spouse now owns the house. And that's the problem. The surviving spouse now owns the house. Because when the surviving spouse owns the house and he or she dies, think about it. They own that house. The only way to sell a house is to sign a deed, right? Right? Everybody, I'm sure a lot of you have done that. You sold a house, you signed a deed. Well, if the owner has died, it's really pretty difficult to get them to sign it. You know, I've tried to figure it away. I cannot figure it away. Other than forgery, you cannot get a dead person to sign a deed. Well, if they can't sign it, who can? Nobody. So it has to go to probate court. And then their executor can sign the deed, or their personal representative, it's normally called. And even if they didn't have a will, believe it or not, everybody in this room has a will. Even though you may not have signed a will, you have a will. And why is that? Because I think roughly 68% of the people in the United States don't have any kind of estate planning. Most people put off estate planning until they die because they think it's too expensive. I don't have any property that I really need to have estate plans for. I'll get around to it. That's the normal excuse. I'll get around to it. I've had 90-plus-year-old clients that I'll get around to it. I'm just thinking, I don't think so. I'm 95, you probably need to get around to it. But that's how people think. So the legislature in all 50 states have drafted laws that provide how your property is going to pass if you die without a will and you have probate property. And I'll have to explain what probate property is in a minute. But a house is a typical example. Once it's out of joint tenancy with right of survivorship and it's named in the name alone of just the surviving spouse, that's going to be probate property. If you have a will, the will will determine who gets that house. If you don't have a will, Oklahoma law will determine who gets that house. And the theory behind these laws are this is what a person would normally be expected to do. It turns out, though, reality isn't met there because here's a typical case. Our Oklahoma law, and it's typical, I would say it's this way in almost all 50 states. If a widow dies, let's say, married couple, let's say the husband dies, and he's survived by his wife and their children, and he dies intestate, and the house, let's say, was in his name alone. Maybe he had it before they got married. He never put it in both their names. Now the husband's died. What do you think is going to happen to that house? And if he had come to me and asked me for a estate plan, I bet he would have said, if I die first, I want everything to go to my wife. She gets the house, everything. If he dies without a will, that house, which is probate property, according to Oklahoma law, would go half to the spouse and half to the children. It doesn't matter if the children are 50 years old or 5 years old. They still get ownership of half of the house. It's not what people want. I guarantee it's not. I didn't have clients that ever said, I want to leave my spouse half of my estate and the rest of my estate goes to our kids. Most of my clients, or almost all of them, said, I want to leave everything I have if I die first to my spouse because he or she's going to need it. And they're going to have a will just like mine, and it's going to say if my other spouse isn't living when I die, it goes to our kids. So the kids eventually get the property, 100% of it, but only after both their parents have died. It's a real surprise when they discover that, oh, our dad just died, and now our mom's going to get half of the estate, and we get the other half. And if in a perfect world, in a Disneyland-type family, the kids might say, well, that's not right. We'll just transfer what we have over to our mom. We'll give her our half that we're legally entitled to. Well, guess what? This is not Disneyland. And money does strange things to people. Really, we have a legal right to half our estate. Our dad must have wanted it that way, even though he died without a will, because he knew what the law was. He knew we did half. No, he didn't. I promise you he didn't. So, I'm dealing here with probate properties. What is probate property? Again, I give you an example of a house. Let's talk about a bank account for a minute. It's almost the same thing as a house. You have your checking account at BOK, and you also have a savings account or money market account. And again, when you're married, you're probably going to have that account as joint cases, joint as survivorship. That's fine. I recommend that to my client. When the first spouse dies, everything in that account goes to the surviving spouse. It's the same problem as with the house, though. When the surviving spouse has that bank account in her or his name alone, if they die under those circumstances, that account becomes a probate asset. And it has to go through the probate court, whether you have a will or not. If you have a will, the will will control. If you don't have a will, Oklahoma law will control. So what are the options? Let's back up here a minute. One option you have, and the best option I think, is to set up a revocable trust. Obviously that has to be done before you die. And they're also called living trusts for obvious reasons. You set them up while you're still alive. And so if you had set that up, you could put the house in the trust, you could put your bank accounts in the trust. I told you how you do houses. You go down and get a deed. That's simple. Same thing with a bank account. You just go to your bank and say, we've got a trust now. My wife and I have a trust, and we want to put our checking and savings account. They have forms to do that. You just fill out the forms. It transfers those into the trust. Nothing changes. Your account number doesn't change. Your checks don't change. But it's actually in the trust. So now, when the second spouse dies, the trust says, upon the death of the second of us, we want everything in our trust to go to our kids, or from our kids, it goes to our nieces and nephews. Or I have a lot of clients that have charitable inclinations, and they say, when we leave half of it to our church and half of it to our alma mater. I mean, you can do anything you want in a trust that you could do in a will. So a trust is really just a will substitute. It does the same thing as a will, but you don't go to court with a trust. When you have a trust, and both, again, a married couple, the husband and wife have died, you have to name what's called a successor trustee in the trust. Because a trust has to have a trustee. The trustee is like an executor in the state. It's who manages what's in the trust. And when you're alive, when I set up trusts for my clients, a married couple, they're going to be the initial trustees. So we've got a husband and wife, they come to me, I set up a trust, draw it up, and in there I specify that Mr. and Mrs. So-and-so are the initial trustees for the rest of their lives, unless they become incapacitated. But then I have to say, but when you both die, there has to be a successor trustee. Somebody who's going to take your place, and they're going to manage your property and follow your instructions in the trust document and do exactly what an executor would do in a probate court. They're going to follow your instructions and distribute your property, just like in court, but it's not going to court. So there's no attorney to hire. It doesn't take 6 months or 2 years. It can happen just in a matter of a couple of months. It doesn't take long. The successor trustee might want to talk to an attorney who will advise on what to do. That's 1 or 2 hours of attorney time rather than 30 or 40 hours. It is significantly cheaper after death of both of the parents for a successor trustee to distribute the trust property. And once that's done, the trust is gone. It's over. It can last longer. If you have, it's not uncommon for my clients to have a child who has some type of illness and not able to manage money. And they want the trust to continue on after both mom and dad are died, because somebody has to manage that property for the disabled child. So you can make trusts last longer, but in most cases, people want their trust to end shortly after their death, and they do end. And very simple, not expensive. And that's why most people prefer trust now over wills, is the way they're supposed to be functioning. But there are a lot of other ways to transfer your property when you die, other than wills and trusts. And so, yes, sir.
Is there any reason to have both a will and a trust?
Actually, and this is confusing to my clients, after I've gone through my whole spiel about why trust is better than wills, I say, so I'm going to prepare these documents for you. It's part of your estate plan. I'm going to prepare a revocable trust, durable power of attorney, both for healthcare and financial decisions. I'm going to make an advanced directive healthcare. And I'm going to make what's called a pour-over will for you. And first of all, they don't get it. You probably don't either. What does pour-over mean? And why are you making a will for me when you just told me I don't really need a will? I just need a trust. here's why you need what's called a pour-over will. When I say pour over, I don't mean P-O-R-E, look at it. I mean P-O-U-R, like pour out of a pitcher. A pour-over will is there simply as a safety valve in case you, the client, forget to put something in your trust that you should have put in, and then you die, and that asset is still sitting out there. And it's not in the trust, which means it has to go through probate court. The pour-over will then has to be probated. So, I tell my clients, I'm going to make a pour-over will for you, and theoretically, it'll never need to go to probate court. But you'd be surprised how many people make a mistake. Maybe they put all the assets they owned at the time that they set the trust up into the trust. But as the years go by, they change banks. They close their account at BOK and go down to some other bank. They open up a checking and savings account, and they forget to put it in a trust. So it's just sitting there in their names. Or they sell their home and they buy another home. And you go to the closing, they don't know that you want to put that new home into the trust, so they just put it in the names of the husband and wife, or just the husband or wife if they're widows or widowers. And so people are people. And so you have to take into consideration the fact that everybody's not going to do everything they're supposed to do. So that will is there just in case, and you'll be surprised how many of these wills get probated. You have to probate that will because they left something out of the trust they should have put in. And after they die, it's too late. You can't put it in after they die. But that's what the pour-over will does. The pour-over will doesn't leave property to anybody. It doesn't leave property to their spouse or their kids. It leaves it to the trust. So you have to go through this whole rigmarole, hire an attorney, go through probate court just to get that asset into the trust after the person dies, rather than before they die, which is when it should have been put into the trust. So every client of mine got a pour-over will, and so because I've been a probate judge, I saw a ton of these pour-over wills probated, which means we're all alike. We're not perfect. We make mistakes. We forget. And maybe as you get older, you forget because you have dementia. It's easy to make a mistake and leave something out of the trust that should be in there. Yes, ma'am.
Can't you put a car in a trust?
You can't put a car in a car. The things that you put in the trust generally are things with a title. And a car has a title. But that's a question almost all my clients ask me. Should I put my car in the trust? And my answer is, you can. There's no reason why you shouldn't. But it's not a problem, surprisingly, with a car if you don't put it in the trust. So it's in your name alone. It's not in the trust and then you die. And you think, do I have to go through probate? It turns out you can go to any tag agency in the city and they will show them a death certificate and you fill out a little affidavit, the form, and they will issue a title in the wife or the child or something. So you certainly can put your car in the trust, but you don't have to because Oklahoma's kind of weird about that. In a good way. You can deal with a car even though it's not in the trust, surprisingly.
If you have listed someone as a beneficiary on your accounts through your financial planner, does it still end up going to probate if you die? Like if I left my financial account, my IRA to my daughter or my husband, and I listed them as a beneficiary, does it still have to go through probate?
No, great question. Let me catch up with you there. Let's talk about other assets. I talked about real estate homes, lake homes. Talked about bank accounts, which checking, savings, CDs. Those are all just regular bank accounts. And then let's talk about brokerage accounts. I mean, you can go to Charles Schwab or Fidelity, they open up a brokerage account where you can buy and sell stock and bonds. And you can set it up two ways. It can just be a regular brokerage account. It's just like a bank account. It's not an IRA. And so if you have a regular brokerage account, it needs to be in a trust. But if you have an IRA, and actually most of the wealth in this country right now is in real estate and IRAs and 401ks. When you think about it, where else would wealth be? That's where most of the wealth is, and I'm talking trillions and trillions of dollars in the United States. It's in the real estate that people own, the 401ks that they had when they were employed, and then in IRA, because normally when you retire, you throw your money out of the 401k and put it in an IRA, which is an individual retirement account. When you set up an individual retirement account or a 401k, you are required by law to name what's called a designated beneficiary. You have to do it. They won't set it up for you unless you do. that's your opportunity then to say, who's going to receive this IRA or this 401k when I die? So my wife and I, we have two sons, they're grown, in a typical family. My wife is a beneficiary of various IRAs that I have. But you also need to name what's called a contingent beneficiary. Because what I tried to explain to my students for years was this estate planning law practice is all about using the what if question. And the what if question is, what if that person that I leave the property to dies before me? So my IRA say everything goes to my wife, but the contingent beneficiary would be our two sons. So if my wife were to die before me, our two sons would be the beneficiaries of the IRA, and they would receive it. If you don't name a contingent beneficiary, you don't have to. They won't make you name a contingent beneficiary. They won't make you name the primary designated beneficiary. They will not complete the paperwork unless you do. But if you don't name a contingent beneficiary, it may be fine, because if the primary beneficiary outlives you, the property will go to them. But if the primary beneficiary dies before you die, and there's nobody else named in there, where do you think the money goes in?
Probate.
Goes to probate. It goes to your estate. Right. So it's important to name a contingent beneficiary.
Have you ever had, okay, say you own property overseas, but you have all the deeds and paperwork here, would that be something important to put into your trust and will and things like that here in the US?
The question was if you own property outside the U.S. It would depend on the law of that country. I mean, I'm going to say ideally, yeah, you would want to do that, but the question is, could you do that? I mean, it's no problem here in the United States. If you own a vacation home in Arkansas, but you're a resident of Oklahoma and you have your trust set up in Oklahoma, you can put the Arkansas home in your Oklahoma trust. That's not a problem. Another country, I don't know if that depends on the country, obviously. So, attorney said you say this, but I don't know. I do not know.
I'm sorry, just a quick FYI. We are filming this for anyone who can't be here, so you might want to be careful just in terms of sidebars, because then they might not be able to hear his answers, so, sorry. Yeah.
Okay.
Okay, going back to contingent beneficiary. So I have two daughters, and if one of those daughters dies, and yet I want the money that she might have gotten to go to her children, how do you handle that?
Did everybody hear the question? That is a great question. Because the revocable trust has lots of benefits, and so does a will with respect to this. You can design a revocable trust or a will to cover all those possibilities. You actually state that. In the revocable trust, you might say, I have three daughters. If one of them dies, I want her share, and the options normally would be to go to her two sisters or to go to her children. And you just say that in the trust so that you know that's what's going to happen. You cannot put language like that in a designated beneficiary of an IRA because corporate America runs these IRAs and there's not room on their minds or in their minds to do that. So what you would have to do, the company's called a custodian, whether it's Fidelity or whoever, they're the custodian managing, holding your IRA funds. They often have their own internal rules. So the first thing you do is ask them that question. If one of my daughters dies, will her share go to her sisters or to her children? And they may have an internal rule that would say that. If you don't like that, you could obviously change it yourself, but that means you have to monitor the situation. And when there's a death in the family like that, you may have to go to the custodian and make some changes so that things end up the way you want them to end up.
So if the follow-up to that, if my daughter's children are minors, do I, in my trust, then appoint who manages their finances?
You could, but now we're getting technical. I don't mind getting technical, but I don't want to lose you guys.
So what if?
There's a law in Oklahoma called the uniform law. There's these uniform laws all over the United States, and they deal with different topics. There's one called the Uniform Gifts to Minors Act. And so Oklahoma's adopted that. And so in the trust that I used to draw, it would say if any of the beneficiaries are a minor, then I give it to their parent, let's say, as a custodian under the Uniform Gifts to Minors Act. I mean, that's getting in the weeds. But that's why it's probably worth the money to hire an attorney to do your estate plan. You can get these revocable trust forms off the internet too for free. But you don't know how to deal with that kind of issue. About, well, what if one of my daughters, how do I get my granddaughter, or how do I want her sisters to get it and not the granddaughter? That's what attorneys do. They help you wade through that.
I'm sorry, I'm sort of slow to learn, but you're saying an IRA with a beneficiary will go to the beneficiary without probate.
Correct.
But an investment account that has a beneficiary will not. It will go through probate. Is that
Well,
correct?
Well, you just said a beneficiary. If you just go down to Charles Schwab and open up a brokerage account, they won't ask you who the beneficiary is because they don't, any more than a bank would. I mean, when you set up a checking account, it's your money. And they're not going to ask you who gets it when you die because that's not what a checking account's designed to do. And the normal brokerage account isn't designed to do that either. It's just like a bank account. It's yours until you die. But there's no beneficiary you can name unless, and here's a big unless, there are ways to do it. Let's go back to a bank account for a minute. When you go to a bank and, well, let me give you an example. How much time do I have here?
You're doing well. 30.
Sometimes examples help. Years ago, I was out raking leaves in my backyard, and my next door neighbor leaned over, and he knew that I did estate planning and all this. He said, I got a story to tell you. Here's what my neighbor told me. He said he had 4 adult children, and they were very responsible. I mean, it was a wonderful family. And he said, I had a CD mature, it's $400,000, and I decided to add my 4 adult children as joint tenants with survivorship because my wife has plenty of money. She would not need that money. And so I put my 4 kids on there as joint tenants with survivorship. He said, again, my children are responsible. It's not like they're on drugs or anything. But he said, my son had his own business and he filed for bankruptcy. And when the bankruptcy trustee looked at his assets and saw that he was a joint tenant with his father on a $400,000 account, the bankruptcy trustee said, you're losing. It's coming to your bankruptcy estate. And the father had no idea that that was even possible because he was the source of the money. The $400,000 came from him. None of his 4 adult children put a penny into it. But yet, remember what I told you about a joint tenant private survivorship? It doesn't matter if there's 2 joint tenants or 5, like in that case. Everybody who's a joint tenant owns 100% of the assets, not their pro rata part. They all own 100%. So the son who filed bankruptcy was considered under law to own 100% of the $400,000 CD. So his dad lost the $400,000 because nobody explained that to him. And here's why they didn't explain it to him. If you go, I've seen this happen so much. You go to a bank and you say, I want to add some people to this account. And you've got a young bank officer there, and they go, great, we got a card for that. They open the drawer and they pull out a card, you didn't take it home, you sign it, they sign it, bring it back. It's tiny little print. And that's only because they've got lawyers. They don't want to read it. If you read it, what you've done when you added people to that account is made them joint tenants with right of survivorship. Even though the bank didn't ask you. Because there are 2 options. Now I'll get back to answering your question. When you have a bank account and you want to add people to it, there are really only 2 options. One is to make them joint tenants and never do that. If I don't get anything done tonight, I want you to understand, don't add your kids or your family or anybody other than your spouse as joint tenants with right of survivorship. Here's the option that you should do. Bank accounts can be made what's called payable on death. And they abbreviate that POD. And when you do that, again, what he could have done, my next door neighbor, if they had explained things to him, and he didn't know to ask, of course, he could have added his 4 children as pay on death beneficiaries. And what that means is they don't own the account while he's alive. So if they get in financial trouble, like actually did happen, the father wouldn't lose his $400,000. But at the father's death, the bank would pay on death that account. They'd each get $100,000. That's what he wanted to do, but nobody explained that to him. And then you mentioned your brokerage account. You can set up, again, they're just like bank accounts. You can set up a brokerage account that's just in your name and there's no beneficiary. But you can also make a brokerage account what's called transfer on death. It means exactly the same thing as pay on death to the bank. So it's abbreviated, not a surprise, TOD. So transfer on death, that's your brokerage account. It's not an IRA. It's just a plain, ordinary, vanilla brokerage account, but it's transfer on death. So at the owner's death, they will transfer it to whoever the beneficiaries are. The only thing you need to watch out there for is what if one of those beneficiaries dies before you? You need to go to the bank or the brokerage firm and say, do you have an internal rule that would cover that situation? Or do I need to proactively make some changes on who the beneficiaries are? Because obviously, if you wanted the children of the deceased child to get their share, you could add it to it, but you would have to do that. You have to be proactive. Because if you just sit back and do nothing, you don't really know how it's going to come out.
Yeah, and if they're minor children, to still say who would administer
Yeah,
that.
yeah. So in those cases, the custodian, the financial institution, they're not following what the law requires them to do. They just have adopted a policy. And by you using them, you've agreed to use their policy. But you can change it. But you have to check and find what the policy is and then maybe be proactive and actually do something yourself. Yes, sir. I'll get you in a minute, Linda. Rick?
Yeah, getting back to living trust, did you say or did you not say it was a good idea or not a good idea to put your IRA in the living trust?
Okay, everybody hear that question? When you fund a trust, I said there were certain assets you should put in it, like your house, your bank account. And I meant to say, and I think I said, but an IRA, it can be put in a trust. I normally recommend against it. Because it's going to go anyway to the people that you designate as beneficiaries. And there are some tax reasons why it's not wise to put it in there. The more wealth that some of my clients had, the more they were willing to pay CPAs and accountants to explain all the tax reasons and why they should or shouldn't. But generally, my clients, probably like everybody in this room, just middle-class citizens, not extremely wealthy, they don't need to worry about tax reasons. And so it's tax neutral if you don't put it in the trust. So again, my recommendation is you do not put your 401ks, you do not put your IRAs into your trust. You don't need to. They're not going to be probate property ever because they're going to go to the designated beneficiary as long as the designated beneficiary is alive. It's kind of a given. And Linda.
But then wouldn't all the other things that you have PODs and TODs on do the same thing?
Yes.
You wouldn't really need to put them in a trust because they should automatically be distributed on death.
True. Everybody hear that? If you've got a pay on death bank account or a transfer on death brokerage account, what's the pros and cons of putting that in your trust? The pros would be, in your trust, you can specify, let's say you've got 3 children. If one of my children dies, I want his or her share to go to her children. Or I want it to go to his or her sibling. You can specify that explicitly in a trust. You can't do that on an IRA because unless the line is big. That's where the name goes. You can't put all that in there. That's when you need to go to the IRA custodian and say, my daughter's died. Do you have an internal policy that controls who gets it? And if the policy is in accordance with your intentions, fine. But if it's not, then you'd have to change the beneficiary sum yourself.
Okay. I have one more.
No, you know what?
On your house, if you have a TOD, a transfer on death on your house, okay, which I do,
Okay.
and it goes to my sister, but my sister and I kind of agreed that like my house would go to one of her kids and her house would go to her other kid. So if I want my house to actually go to one of the kids, but it's going to Judy first, and she will decide which kid gets the house or whatever. But then when she inherits the house, I mean, it's, there's no tax because it's so high. But if she then gives it to a kid, would they pay tax, special taxes on receiving it like as a gift then, I guess?
No. And we'll get into gift taxes later tonight, state and gift taxes. A lot of people that, not attorneys, but there are a lot of people who are not attorneys who make a living at these big trust mills, I'm going to call them, where they churn out trusts by the hundreds and they invite you to a real expensive dinner. And really what they're trying to do is sell you a trust, and they try and scare you by saying, don't let the government get your money. The taxes are going to decimate this. And I'm going to explain to you, unless you're surprisingly wealthy, you don't have to worry about estate taxes. And I'll explain why here later tonight. And I guess we have until 7:30?
Yep.
Okay. I'm just getting going. Sorry. I can talk all night on this. Linda mentioned something that I haven't mentioned yet. I'm glad you did. I don't know if you caught that. She talked about a house, real estate, and I told you, a joint tenancy, the right of survivorship for a married couple is fine for a house. It's not a good idea for a widow or a widower because it's gonna go through probate unless you do something. And I said the thing you should do really is put that house in a trust and then it won't go through probate. That's all true. There is another option, and that's what Linda just mentioned. 6 or 7 years ago, the Oklahoma legislature passed a law which provided, and we had never had this option in Oklahoma before, but they provided a process called it's not transfer on death, it's drawing a blank, but that's what it means. You can now take real estate and fill out one of these transfer on death deeds and go record that at the courthouse, and it does exactly what it sounds like it would do, just like a transfer on death brokerage account or a pay on death bank account. You name the beneficiary, we're going to get your house when you die, and if you do that, that house won't be a probate asset anymore. It won't go through probate. A house will go to whoever you have specified by name. So it has all the pros and cons of all the other transfer on death. It works great if everything occurs as you anticipated and hoped it would. But again, if one of those transfer on death beneficiaries dies before you, then you've got an issue again. Who's going to get that person's share? Which means you might need to make a new transfer on death deed that's a little bit different. It might just include the surviving children. And it might include the children of the deceased child, which are your grandchildren. So again, you have to monitor the situation. But there is a way to make a house not be a probate property other than a trust, and that's this transfer on death deed. So, and Linda mentioned she had, which is great. I mean, that's a new kind of arrow in the quiver for estate planners, because we didn't have that 10 years ago. So there's lots of ways that you can keep your assets from going through probate. There's really no reason that your property should have to go through the probate court. Unless you make a mistake. You set up a trust and you overlook something, either initially right off the bat or as the years go by. You acquire some new asset that would be a probate asset, like a house or a bank account, and you forget, put it in trust. Yes, Kathy?
One thing that people have told me is an advantage of a trust is that it's a private document, whereas a will is a public document. Is that correct?
It's true. When you file a probate case at the courthouse, first of all, you have to have the original will. That's a problem for most people. If you're like me, keeping something for 10 years and finding it 10 years later is not easy. I mean, it's difficult. I often have people calling me saying, and I've got a case right now, here I am retired, a lady called me and said, you prepared a will for my husband 15 years ago or something, he's died. But she said he had dementia. I don't know where he put his will. Do you have a copy? And they just think if I have a copy, that'll be fine. Like I said, wills have been around a long time, and the law has been developed around them from England, and a lot of it's come from the United States. And there can be fraud involved when there's a lost will. And so generally, to probate a will, it's required that you have the original will. Well, that's fine if you still have it, but what if you don't have it? What if you lost it? What if you can't even remember where it is? Can you probate a copy? Sometimes yes, sometimes no. That's not a situation you want to be in. So if you're going to have a will, you need to retain the original. If you're going to have a trust, actually, surprisingly, not surprisingly, because they have been around for 200 years. A copy's fine on a trust. You don't need the original. So, you know, I mentioned this digital vault. You make PDF copies of all your legal documents. That would be another plus for having your revocable trust digitally held in your digital vault. Because if you ever need a copy, you can print out a copy, and take it to the bank or whoever, and they'll honor it. Other questions?
When you take it to the bank, do they keep it or do they look at it?
They just look at it.
Yeah, okay, because that's what you say, you might have to have multiple copies of this trust.
And to Kathy's point then, when you probate a will and you file it at the courthouse, it becomes public record. Anybody can see your will. And so when I used to teach the class, it's interesting. You can get wills from hundreds of years ago. You know, I got a copy of George Washington's will. I got a copy of all these famous people because they've been public record from day one. And if you don't like people seeing it, it won't have Well, the will won't have how much your property is worth, but when you probate the case, generally you have to file an inventory and list all the property and list what it's worth. And then your nosy neighbor can look at the probate case and see exactly how much this diamond ring was worth or how much this brokerage account had in it. People don't want that. They don't want their financial underwear spread all over the neighborhood. And like you said, Kathy, trusts are private. You don't, not only do they not go through probate court, you don't even file them at the courthouse. Nobody can see what's in your trust at all. It is private. So as you can see, there's all kinds of reasons for doing a trust as opposed to a will. The only thing that holds people back sometimes is when I did trust wills as estate planning, I charged more for doing a trust than I did a will because the trust is more involved. Because you actually have to draw out a plan. A trust, for the day it's signed until you die, that's one thing. And so your property's in the trust, and the trust says that the trustee, that's the client, it's the husband and wife, can pay money out of the trust to themselves so they can live on it. But a lot of times, my clients had unusual family situations, and they've got a child who has a physical illness or mental illness or criminal problem, and so you get these kind of sub-trusts to deal with those. And it just takes time to draw them up and make sure they're doing what the client wants, so they get a little more expensive. Rick?
If I have an asset now that I did not have when I set up the trust, do I need an attorney to put that asset in the trust?
No,
How do I put it in the trust?
depends on the asset. Real estate?
Well, let's say it's a painting, let's say it's a piece of art.
Things that don't have a title. That's called tangible personal property, things you can feel and touch. They're physical. When I set up a trust for my clients, I have a kind of a blanket clause that says, it's an assignment, it's the last page. I hereby assign to the trustee of my trust all my artwork, guns, jewelry, clothing. It's just a lottery list. And so that's really how you get that painting into the trust, because there's no title. There's no place you can take, even if you had a title on a painting, and record it. So
Should you put the painting in the trust?
if it's valuable, I would say yeah. And if it's really valuable, I would just have a one-page assignment. It would describe it. Painted by such and such, of this person, I hereby assign it to the trustee of the trust. Here, another.
But these days, would you have a picture of it?
It would help.
Yeah.
Here's another example of what you can do wrong in a trust. I had a lady call me once, and she was referred to me, so I didn't know her. Went out and met her, big home in South Tulsa. And her husband had just died. He was an executive with a big oil company, and they're quite wealthy. And we started talking, and she said, well, the good thing is my husband had a trust. He had a revocable trust. I said, that's great. Then we shouldn't have to probate anything unless he forgot to put something in it. I said, let me see the trust. So she, real thick. It was one of the top law firms in Tulsa. It was very well done. It was an excellent trust. And on the back of it, a lot of attorneys, and I used to do this too, it said, here's Schedule A. Here are the assets in my trust. And it listed all kinds of stocks and bonds. It went on for a couple of legal-sized pages. Well, guess what? There wasn't anything in his trust. He was under the mistaken impression that because those were all listed as part of his trust, here's a piece of, it's a document, maybe a half-inch thick, stapled together, and the last 2 pages of Schedule A, it's all these stocks and bonds, and they're worth hundreds and hundreds of thousands of dollars. The firm never explained it to him, or he never knew to ask whether that meant that those assets were actually in the basket they had been put into the trust. Stocks and bonds have a title. I mean, you go to your broker and you have the stocks and bonds transferred to the trustee of the trust. It's not difficult, but he didn't know you had to do that. So he had this beautiful trust. He had paid a lot of money for it. It had 0 assets in it. And I said, tell me he had a horrible will. And of course, she said, what's that? And I said, well, I know this law firm. I'm sure they made a horrible will for him when they made the trust. So she got through all his papers, and we looked and we found it. And so the horrible will said, I transferred to my trust. I'm going to paraphrase, everything that's not in the trust before I died. Well, everything he owned wasn't in the trust. So we probated the will, but it took a couple of years because he had a complicated estate. And all that money could have been saved, and in the time, if he had understood it, and I can't fault him for that. I mean, he didn't come to a seminar like this where he learned just signing a trust doesn't put anything into the trust. You have to actually do it yourself. He was under the impression because everything was listed, it was in the trust, and whoever the attorney was at that firm probably explained it, but probably didn't explain it well enough. Oh, by the way, all these stocks and bonds, you transfer them to the trust yourself after you leave here today. Some attorneys take it on themselves to actually do the transfer. I thought about doing that once. That's time consuming. And they don't want to pay my hourly rate to spend another 100 hours putting all their stocks and bonds in the trust. They can go down themselves and do it for free with their broker.
When they come in and sign the trust with us, we give them a letter that says, now that you've created this document, you got it. And we give them forms, a Form D, where to find it, because now you can tell them, go to the county's website, and here it is, just click on it.
Yeah.
Give them that, we give them form letters, show them what the bank will give them, just kind of a little packet
And
saying,
that's what people need. Everybody heard what Phil was saying. And I did the same thing. My clients would sign the trust, then I would have a letter that explains, now you need to transfer in, and I gave a real thick instruction sheet. Here's how you transfer your house in. And actually, I always figured I wanted to make the deed to the house rather than them go home and type it up on their computer. So one of the few services I provided in transferring assets into a trust for a client was I would prepare a new deed to their home. So when they came in and signed the trust, they could sign the deed on the same day. And then they would go, or I would go down to the courthouse and record the deed. I would put their house in the trust. But I explained, you do everything else. Here's the instruction sheet on how you do it with stocks and bonds and bank accounts. And it's not difficult, but it is time consuming. And so if they don't spend the time to get everything in the trust before they die, there'll be something left out of the trust, and then we'll have to probate their horrible will, and that was not the goal. Their estate plan was to avoid probate court. Yes, sir.
So, my securities assets are in ETFs and mutual funds. Would I have to have the individual stocks listed in the trust, or with just naming the mutual fund or the ETF?
Mutual fund should be fine.
Okay. And I had a second.
Most people don't, I shouldn't say most, but a lot of people don't own individual stocks anymore. They own mutual funds.
Yeah.
Yeah, so it's the fund that goes into your trust. Yeah.
And I had a second question.
The fund might have 50 stocks in it.
Yeah.
One of those buttons. So.
My second question is this: I've provided for my children through irrevocable trust, and with what I have left, I'd like to give that to my grandchildren at a certain age.
Mm-hmm.
And I'm wondering what a good vehicle to do that was. I understand from that irrevocable trusts are taxed at the same rate as ordinary income, and I'm just wondering what should I do in this situation? I want my grandchildren to have.
How old are they?
Not born yet. my presumed grandchildren. But what I did with my kids was I opened the trust when they were a month old.
Well, remember I mentioned the Uniform Transfers to Minors Act.
Yeah.
You could give it to their parent as custodian for this child. They don't wait till they're born.
Yeah, I understand that.
And then, by law, the parent can hold it until they're age 21. And you don't have to set up a trust or anything. It's like that's kind of a package trust that's already written for you, but it's in the legal books.
Okay, but I wouldn't want them to have access to the money until they're a lot older than 21.
If you want to go beyond 21, you're going to need a trust.
Okay, and the trust, irrevocable trust is the way to go?
Not necessarily. You need to talk to a tax expert.
I'll do that.
Okay. Speaking of taxes, because we're down to the last nitty gritty here, turn to the last page on my handout. I think it's the last, it's my handout, not the color one, but the one that says planning for the inevitable. Here's one.
Got it.
I think it's the last page. Does it say it's getting?
Yes,
Okay. Everything I'm going to tell you about taxes is good news. All right, let's talk about estate and gift taxes. Again, like I said, when you see these full-page ads in the newspaper for a trust mill, which is they want to sell you the trust. How are they going to scare you into coming and partying with your hard-earned money to get them to build it, make a trust for you? They're going to say, oh, the government's going to get all your money, all the taxes are going to eat up your estate. Well, look at what I wrote in here. There's two taxes. There are taxes on estates called estate tax. That's a tax on the privilege of transferring property to someone else when you die. That's an estate tax. There is a gift tax, and that's the tax on transferring property to someone during their lifetime. You see from that handout, the good news is Oklahoma used to have both an estate and a gift tax. We haven't had it for over 10 years. So there's no Oklahoma estate or gift tax. And the good news from the federal side is there's an annual exclusion on gift taxes, and you can do, it's gone up by, it's reset for inflation every year. It's right now $19,000 per person per year. What that means is you can give up to $19,000 to as many individuals as you want every year and not have to file a gift tax return. And that'll be indexed for inflation, so it will go up a little more next year. It doesn't mean you can't give more than $19,000. Well, first of all, a married couple can use each of their exemptions. So they can do 2 times 19, which is $38,000. A married couple can give $38,000 a year to as many people as they want and not have to file a gift tax return. Even if you gave more than, let's say, $19,000, that's a taxable gift, but actually you don't pay any tax. Here's what happens. Then you do have to file a gift tax return, and all you're doing is reporting it to the federal government that you've made a gift over $19,000, but you don't pay any tax. What happens is, look at the next sentence. There is a lifetime exemption of $13.99 million for every individual in the United States right now for estate and gift tax. So on the gift tax, if you make a gift over $19,000, say $5,000 more, that's a taxable gift. All they're going to do is subtract that $5,000 from your $13.9 million. I don't think that's a big deterrent to making a gift of more than $19,000. If you have the money to do it, do it. And if you don't file a gift tax return, you'll be alone in good company, because I think most people that should don't. But look at the estate tax. It's $13.99 million per person. Next year it will be $15 million. Unless your estate is larger than $13.99 million and you die this year, you don't have any estate tax due. Well, I'm going to guess that probably exempts everybody in this room. Me, you, if you have that kind of money, you probably wouldn't be here. You'd be paying an attorney and a CPA to give you tax advice.
Do you still have to file an estate tax return?
Only if you're greater than that amount.
No.
But there is, okay, Steve asked if you have to file an estate tax return even if there's no tax due. My answer was no, you don't have to. But you might in one situation, and I covered it in that first paragraph, or second paragraph, when I talked about capital gains tax. Now we're really good at the weeds. I apologize in advance for this, but you need to know this. You all kind of know what capital gain taxes are. If you buy an asset and you keep it for 5 or 10 years and it increases in value, then when you finally sell it, that's the gain. Let's do an example. You bought something, a painting, for $100,000 and kept it 10 years, and it went up to $500,000, and then you sold it. You just made a $400,000 profit, right? And you have to report that as a capital gain income on your income tax return. Now, this is income tax, not estate and gift tax. But you report a $400,000 profit, and you have to pay a tax on that profit. That's what a capital gains tax is. But we have this provision in the law that allows, if you don't sell it and you keep it till you die, and then you give that painting to your daughter, she gets what's called a step up in the cost basis. The cost is what it cost you. So even though you only paid $100,000 for it, by the time you died, it's worth $500,000. Does she have to pay a tax on that $400,000 profit? She does not. It is totally escaped. And her basis is now $500,000. Her cost basis for her tax. So if she sells it a year later for $500,000, which is what it was worth when her dad died, she doesn't pay any tax. If it goes up in value after she gets it, then she might have a little bit of tax. But that step up in basis, I have a friend whose dad bought a house over, I just found this out about a week ago, over near 34th and Lewis in the early 1960s for $70,000. It was a kind of a big ranch house with 2.5 acres near 34th and Lewis, a great big pond on it, and his dad's now 95. And his dad's gonna move into an assisted living center. And his dad's still confident, and they were talking about what should we do in the house. And the father said, well, I know there'd be some capital gains tax, maybe it's worth $1 million, and I paid $70,000 in the 1960s. And the son said, Dad, it's 2.5 acres. It is worth a lot more than $1 million. It's probably $2.5 million. The capital gains tax on a $70,000 asset that's now worth $2.5 million. He said, Dad, you know how much the tax would be? And the dad said, so what should we do? And the son just said, let's just keep it until you die. And then we can sell it. The family can sell it. We can do something with it. His dad's 95. His life expectancy is not long. And the dad said, the dad doesn't want to pay any taxes. He goes, that's great. I don't want to pay $1 million to the federal government. I'd rather let's keep it, even though I'm not living in it, keep it till I die. Then you all can sell it, and there won't be any capital gains tax. Wahoo! Pretty nice, huh? And that's what the step-up in basis. When Barack Obama was president, he floated an idea out there about this step-up in basis. He said, we've got this huge debt, trillions and trillions of dollars. He said one way to get that debt paid was eliminate this step-up in basis thing. So if you inherit property from someone when they die, you have the same basis they have. So if you sell it, if you sell that painting for $500,000 that costs $100,000, you pay the capital gains tax. And the Congress immediately shot that down because it'd be very unpopular. Everybody likes this step-up in basis thing for his reason. It's a way to avoid paying tax on profit. Yeah.
Does that hold for securities as well as
Absolutely.
paintings and okay?
Securities, anything that would have a capital gains tax can be avoided. To keep it, well, it doesn't help you, except you don't have to pay the tax. You die, and now whoever gets it, they escape the capital gains tax.
Rick, how do you know that painting is worth $500,000 and it hasn't been sold? Get an appraisal.
You do get an appraisal, but here's to follow up with Steve's question. Steve said, if your estate's under $13.99 million, do you have to file an estate tax return? And I said, no, and that's true, you don't. But you might file one anyway, because if you have that $500,000 painting, how do you know what it's worth when you die? The only way, like Phil said, is to get an appraisal, and so you pay an accountant to file an estate tax return, release that asset, to show its date of death value, and that establishes it.
And so there are organizations or companies that provide certified appraisals that
Sure.
that hold up in court.
Mm-hmm. Absolutely. Yeah. So you might want to file an estate tax return simply to establish the basis for the recipient of that property when the previous owners died. Otherwise, it's just their word. Who knows what it's worth? But you get a good appraisal. There are obviously fly-by-night appraisal companies too. You got to be careful about that. But yes, Bill.
Well, in thinking of time, do you want to cover power of attorney before we close?
Yes, thank you. John Frame did a great job on medical powers of attorney, but there are financial powers of attorney, and they're extremely important. So I gave one in your handout. That's another little form that was just adopted a couple of years ago. And they're a great idea. I mean, I recommend to all my clients that you get a financial power of attorney in the event that you become incapacitated. If you can't manage your property anymore, somebody's going to have to do it. And you don't want a guardianship, right? You definitely don't want to have your family have to go to court to file a guardian for you. So you need to sign a financial power of attorney. But this form that Oklahoma has adopted, it's called the Oklahoma Statutory Power of Attorney form. That's fairly new in our Oklahoma legislature, but it was a uniform law. Our legislature is not smart. It's just a uniform law that they adopted. But it's complicated.
Yeah.
When you look at, there's some things that shocked me when I saw that. Okay. Turn over to page 2. I know they're not numbered, but turn the first page over. And if you're going to sign one of these, you are authorizing your agent to do anything that you initial here, or the very last one says, all preceding sections. So if you initial the very bottom one, you're authorizing your agent to do all those things. And actually, I think all those are probably a good thing. You know, it starts out with deal with real property, tangible personal property, the painting, all that. But then, you go down to the bottom of the page, grant a specific authority. It says that my agent may not do any of these things unless I initial those. And you turn the page, and you page 3 and look at those. Look at the options you have to authorize your agent to, number 1, create, amend, revoke, or terminate an inter vivos trust. So you went to the trouble of setting up a revocable trust. You specified who you want to receive the property when you die. And you're going to authorize your agent to terminate it, change it? I don't think so. I think that's the worst idea I've ever heard in my life. Create or change rights of survivorship. Something's in survivorship and you can take the survivorship off. Create or change a beneficiary. Now these are by default not going to happen unless you initial those. But if you initial any of these, you're giving the agent the authority to do that. Oh my gosh. Authorize another person to exercise the authority granted under this power of attorney? Well, your dad chose you to do the power of attorney because he trusted you. But you've got a guy down at the bar that says, no, I can do that. So you authorize him to start making the decisions for your dad if this is checked, because it says you have the right to delegate that authority to somebody else. The only one I saw in there that you might want to choose is the next to the last one, access the content of electronic communication. I think that would probably be a good idea if you were an agent. So if your dad is incapacitated and he had checked that box, then you as his agent could access electronic communication, his emails and that sort of thing. I think that's probably a good idea. But again, you'd have to discuss that I would have to discuss it with the client. I don't think you all should use this form without talking to an attorney. It's a pretty dangerous form. I mean, if you really understood it, you could use it correctly. Chances are you wouldn't give any of these special powers. Make a gift. For an agent to make a gift, that's always a problem. Using his dad's money to make a gift, because who the hell can give it to themselves? One last example. When I was a probate judge, I often heard cases where someone, usually a sibling, would sue another sibling over a power of attorney. And this is typically how it happened. The daughter hires an attorney, and they come to me and they file a petition and they say, our parent or my mother, whoever, appointed my brother as his agent under a durable power of attorney for financial affairs. Our brother is unemployed, doesn't have any money, but he has a new pickup truck, and his kids are now in private school, and they just went to Europe. How is that possible? I've asked him to give me accounting and show me how he's taking care of mom and dad's money, but he won't do it. He doesn't have to. And so they have to sue to give a court-ordered accounting. So all I'm saying there is, money does strange things to people. I'm sure when the parents appointed that son, they really trusted him. That's why they chose him. But you can be wrong about people when money's involved. You know, the very last thing I put on there was choose wisely. You recognize where that comes from? Do you remember that line from the movie? Dan Hutchinson is fond of quoting lines from movies. Think back to the Indiana Jones movie, The Last Crusade. You know, he gets inside this cave and here's this English knight who's tottering around. He's been there for hundreds of years. He's protecting the Holy Grail. The protagonist comes in and the knight says, choose wisely. And right, it's the chalice, it's the wrong chalice, and he dies. So choose wisely. When you guess
is expensive.
Amen. Choose wisely when you name somebody to have your financial power of attorney. Because if they're using the financial power of attorney, the chances are you will not be able to monitor what they're doing. Almost by definition, you'll be incompetent or incapacitated. You'll be unconscious maybe. So you can't look over their shoulder and see if they're doing everything they should do, nor can your other children, because they've got the durable power of attorney, not the other children. Yes, sir.
Is this subject to the rule that it's only in place as long as the grantor can change it?
Yes. If you give a power of attorney, whether it's medical or financial, you can revoke it anytime you want. Anytime you want. And oh, here's another thing. when the person who gave the power of attorney dies, the power of attorney terminates. That's a misconception with so many people. They got the power of attorney for their mother, and their mother died 5 months ago. And they think they can still go to the bank and transact business with the power of attorney. I'm just, no. Power of attorney ends when your mother dies. If you want to do anything after she dies, it's only because maybe you're named as the personal representative under her will, or you're the successor trustee of her trust. But the power of attorney has absolutely no authority after the principal, called the principal, after the principal dies. That terminates it. But the principal can also revoke it whenever he or she wants. So if they start suspecting that their agent is doing something they shouldn't be doing with their money, they can easily revoke it and make a new one and appoint another kid to have the power of attorney.
I had something that happened when I was an executor of an estate, and I went to the bank to close it out, and they wouldn't let me. They said that she was dead and she had a beneficiary on there, and they said they would have to send the money to the beneficiary. They wouldn't even tell me who the beneficiary was.
And they're right, because remember I told you one way to keep a bank account from going through probate court is to make it pay on debt. And if the pay on debt account, the bank is legally obligated to pay on the account on the debt to that person. It's not a probate asset, which is why they can't touch you.
What did you tell people about keeping their documents in a safe deposit box?
Well, they're safe. They're so safe that nobody can find them or get in it. Which is why I like this digital vault thing. You know, but where do you keep them? It used to be that you could file your will at the courthouse, but they quit doing that years ago. And then most people aren't doing wills anyway. They're not doing trust. There's no place, and you don't record your trust at the courthouse. I said, well, you can use a fireproof box at your house. And a safe deposit box is not a good place to keep it for those two reasons. But it's still better than nothing. I mean, sometimes you pay, I don't know, a few $100s, and the bank will have a guy come in with an electric drill, and he'll drill a hole in the box and open it up because the key's lost and the owner's dead, and you're the executor. You've got the papers to show you're the executor. So they'll drill out the box, and that's how you get it.
We get 2 keys. I gave mine to my other key to my daughter. It's the executor of mine. So she.
When they drill out the box, it's because all the keys are lost. I've been there. Don't ask how I knew that. It's 7:30. I mean, I could power call out on this. So after you leave here, if you want to ask a question, come on up, because this is what I did for my whole career. Thank you for putting up
Before you leave, just a quick commercial for our next couple sessions. The next session will be on planning memorial services and funerals. I'll be leading that along with Cassandra Carter from Stanley's Funeral Home. We'll have materials for you, and then the one after that will be on caretaking, whether you are the caretaker or the caretakee. There'll be some tips for success that'll be led by Denise Brown, our care visitor and a physical therapist. And then we also have James Cunningham, who's a chaplain for a hospice group. And then our last session will feature our beloved Wally Johnson. He's going to be leading us on spiritually preparing for our own death or dealing with a loved one's death. And I'll also be covering the ministries and resources available to you through the church and a few from the community. So I hope you'll continue. Also, we wanted you to know that a book that John recommended called Being Mortal, which that was from the 2017 class. I found it in my notes and read it and thought it was really good. We have, I think, 8 copies of that available to you at the book table in the atrium. So next time you come by the book table, you could ask for that and you get that.
Kathy, another really good one is At Peace.
Thank you.
Excellent. It has a whole chapter on dementia.
Good. Okay. Thank you. So thanks for coming. Yeah.
There were some forms that were not available tonight. So can you email, or can we email you to ask you for them, or have you want?
Yes, I have I can do them digitally, and I'll also bring the copies, like I had the copies from last week here tonight, and I'll have copies from this week as well.
Okay.
And I'm on Realm, so if you email me if you need copies, I've got them. That's what I'm
Yeah.
I can email them to you also. Just let me know.
Go directly to the source.
They're just the same.
Thank you again.
Yeah.